estate brokerages. Learning objectives. We're not going to go over this. This isn't a lecture. I'm going to hit the highlights of these chapters, and we'll go over a few of the exam questions. So on page 117, we talked about the fact that even though we call ourselves salespersons, actually we're brokers. And brokers bring parties together and get paid monies for doing so. On the next page, on this third paragraph from the top, page 118. Oh, my bad. I've got to figure out that. What did that message say?
That you're just recording live.
Okay, and now I just had a, all right, I guess somebody admitted them. So anyway, here we are, back to the material. Hopefully the third paragraph down from the top of page 118, you have highlighted, can receive compensation only from that broker. I'm telling you right now, there's going to be at least 2 questions challenging your knowledge of that fact. You'll never get paid from another company, from a buyer, from a seller. If you're getting paid, by God, your company's name better be in the left-hand corner of that check. So at the bottom, we talked about the independent contractor versus employee. We talked about if you're an employer, an owner of business, and you employ your people. I keep looking at the wrong camera. I got 2. It's easy to be corrupt. There are a lot of people that tell the IRS, my people are independent contractors, but they treat them like employees and make them be at work at a certain time. You get off at a certain time, you get so long a lunch, personal days, vacation days, sick days, etc. So guys, if the IRS ever audits your company or ever audits you, they're looking for this corruption. So in the left-hand margin, I don't know if I told you, but I've been told this is on the exam, about middle of page 119. Did you highlight that third button where it says a substantial portion of the sales associate's income? This is down from top of page 119. The third bullet. If you don't have highlighted, highlight it. But in the left-hand margin, I want you to write 90%. So here's the example. Let's say I'm a school teacher and real estate is my side hustle. So on my tax return, I have 2 sources of income. Got my teaching income, got my real estate income. Let's say I work for Golden Dome Real Estate. 90% or more of my Golden Dome income, not my total income, just my Golden Dome income, has to be tied to units sold, or what they call production, and not hours worked. That would validate to them I'm a legit independent contractor. Now, when I was you and I was told this, I thought, why 90%? Why not 100%? I answered that question in my mind. Remember when I told you it's important to know the why? It'll cement it in your brain. I know for a fact there are some agents that are part-time and they ask their broker, instead of you paying someone, can I cut the grass on the weekends here at the office? I need some folding money. Or there's some people, part-time agents, who will tell the broker, instead of paying a cleaning service, I'll clean the office 3 nights a week, empty the garbage cans, clean the bathroom and the kitchen. So I would imagine the 90% is taking into consideration you might be an agent and still doing some things for cash for the boss, So just 90% or more of your income would have to be production and not hours worked if I got audited. Now, we talked a little bit about real estate assistants. Turn the page. From the top of page 120, I don't know if I asked you to highlight this or not. You may have not. If not, let's do so now. On the second paragraph, highlight the second sentence. It begins with usually. That's the first word. Second sentence, second paragraph from the top of page 120. I'm going to tell you what you highlighted after you highlight it. So if I'm a top producer and I feel the need to have an assistant, if I hire an unlicensed assistant, that's my job to pay that unlicensed assistant, not the owner of the company. If they're a licensed assistant, it is now the broker's responsibility, because the broker is responsible for all licensed people. That's what you just highlighted. That shouldn't be easy for you to remember. It should be easy, rather. So we talked about at the bottom of the page, you know, interestingly enough, we're not hired to sell real estate. We're hired to procure a ready, willing, and able buyer. And when that ready, willing, and able buyer steps forward and makes a full price unconditional offer, there's no question of whether or not the real estate commission has earned that commission. I told you that I've had feedback from students that there's a question on there where your buyer was ready, was willing, but in court, you could not prove they were able. And to be able, I would have to prove to the court that either I had the ability to get mortgage financing or I had the purchase price in cash. One of those two would prove to the courts I was able. So if I can't prove all three, then I would not be able to successfully sue for a commission. But while on the subject of suing for a commission, look at the bottom of the page. That's the first of the three bullets, the things I have to provide if I'm suing for a commission. They're fairly logical requirements of the court. I'd have to prove I had a real estate license. How else could you sue for a real estate commission if you were not licensed at the time in question? At the top of the page, anytime you sue someone, gang, you got to sue them for a specific amount of money. So I have to show them the listing contract, because on the listing contract, it shows the judge how much they promised to pay me. So that's a logical requirement. And then I would have to prove I was the procuring cause of the sale. And I think y'all learned that to be the procuring cause mean I could just set a set of events to take place through my actions. A billboard on the interstate makes them call their agent, who then comes to me and makes an offer on my listing. I'm the procuring cause by virtue of the billboard. So I don't have to directly produce the buyer. My efforts could indirectly produce the buyer. Over here on page 122, you see an example in the middle of the page, a scenario on where they're asking you, how much did Helen make? I just made the name Helen up. I don't know whose names are involved, but if you want to study that outside of class to hone your math skills, if that's within your skill set. Hey.
I was taking a practice quiz today.
Yeah, there's no procuring cause with an open listing. Great question. Open listing, there would be no procuring cause. Okay, yeah, good question. You have to have exclusivity, and that's the one thing that there is. Yeah. Page, well, no, not necessarily. I could sue in an open listing. If I produce the buyer and you accept it and you don't pay me a commission, I could sue. Right. Yeah, there wouldn't be any procuring cause in an open listing, but that's a heady question. Turn to page 124, antitrust laws. You know, we talked about America being a free market economy. In order for a free market economy to work as intended, you have to have healthy competition. Healthy competition drives prices down, quality up, as long as people are vying for our business. So obviously we know that big business, they're good at finding loopholes and trying to avoid laws to do what they want to do. So price fixing, group boycott, allocation of market, etc. But the key is competitors. Like I told you about a common question I hear that's on the exam. Let's say I own a real estate company and I got 4 agents. I give Andrea the north side of town. I give Tim the south side of town. I give Billy the east side of town, and I give Cindy the west side of town. I've allocated the markets amongst my salespeople. Have I violated antitrust laws? No, I haven't. It takes competitors conspiring to allocate market. That's the key. And there's a sneaky feeling. You remember when we talked about this, I told you that more often than not, it is the federal government pursuing companies for antitrust violations. But if an individual did, you see where you've got it highlighted. If I could prove damages, I would get triple damages as a jury award. You know, page guys, again, let me emphasize, if I'm you at this point, this is how I'm studying. I'm starting with number 1, and I'm just going to check off. And I'm going to work my way through this entire outline. Tells you exactly how many questions comes from each sub-subject of the main subjects. So I've looked through it. I'm still adjusting to this stuff because things have changed. Pearson Review just is not, they do things a lot differently as far as the content from different subject areas. So I'm still learning. So believe it or not, well, let's go to page 130. Prohibited communications. See, this would be on risk management. There's compliance with federal regulations that involve privacy and do not contact. Well, these are all those. Do not call list. That's a do not contact. So there were 3 bullets that we needed to know about the do not call list. First of all, just for the fun of it, while you're studying, go to the Federal Trade Commission's website and put all the phone numbers you want in the do not call list. It's going to lessen the amount. It's not going to eliminate them. These modern telemarketers, they know how to get around stuff, but it will lessen them. And it will be a learning lesson. It'll resonate in your brain. You'll remember this. The Federal Trade Commission is the source of the do not call numbers. That could be something you know. And if I'm a company that does regular ongoing telemarketing, they would want me to update my list. Just to get the do not call list once a year and lean on it all damn year, they think is not good enough because you can go in there anytime throughout the calendar year. So the logic is they want me to update my list every 31 days or monthly. Okay, that's fair. And then the 18-month rule. Like if I cancel my Capital One card, you know, they make me angry. So I pay my balance off and I call them. I say, I didn't cut my card up, close my account. They can continue telemarketing me for 18 months from the most recent activity. And then you don't even have to write this down. Unsolicited faxes are illegal. Okay, that's easy to remember. And then we got the CAN-SPAM Act, which is the electronic version of the do not call list. Only 2 bullets. You got to have an easily findable opt-out option. Okay, that's easy to remember. Makes sense. And then you got 10 days to get the opt-out out. So if I send you an email on Tuesday and you opt out Tuesday night, and then my servers are continuing to spin and they send you another one on Thursday, the government's going to give me a break. 10 days. Now, during this stage, gang, I am welcome to answer any questions that you may have. Be difficult to answer a chat. Let me see. I don't know if Ashley is anyway. I hate this Zoom crap. It's just a crappy product. Caveat emptor means let the buyer beware. 220 years ago, the entire country from a legal standpoint was buyer beware. Which means what? I'm the seller of a home. I know stuff's wrong with it. And I'm standing in front of it with my arms crossed, and the law don't expect me to tell you one thing that I know that's wrong with my property. It's your job as the buyer to either inspect it yourself or hire a professional to find out if there's things you don't like. Okay, I don't got to volunteer. That's why they say buyer beware. Seller ain't gonna share. See, I just came up with that this morning. Swear to God, that's my new little poem. Buyer beware, seller ain't gonna share. So, and then we discussed the fact that I've had a student tell me there was a question on there that says, what does caveat venditor mean? And I think we established as a class that venditor is a Latin word. The modern version of that is vendor. And we know a vendor is a seller of things. So caveat venditor means seller beware. Over here on page 139. These are some definitions of terms that are involved in the subject of agency. And if you could recall, I've told you more than once that you need to know every possible word somebody could be referred to as. Like if I'm an owner of a 100-unit apartment complex and I hire Blue Wall Property Management to manage my 100-unit apartment complex, and they're going to talk about me, the owner of the apartment complex, and the question, they could refer to me as the owner. They could refer to me as the principal. Remember, the principal is the word for anybody that's hired us. They could call me the landlord. They could call me the lessor. Okay. So just be comfortable recognizing people by the various terms they may refer to them as. And here's a list that may help you do that. Don't forget the non-agent position, which is the last bullet. You know, chicken egg. When I first meet you and a conversation begins, I don't become your agent until down the road you sign an agreement. So until there's ink on a form between when we first begin a real estate conversation and when ink is on the form, what am I? I'm a non-agent. Different states have terms. In Alabama, we call it a transaction broker. But point being is, until you sign something, I ain't your agent and you ain't my client. So I can't provide you client level services, which means I can't give you advice, recommendations, suggestions. Only once you put ink on paper can I do all that stuff. Turning the page. You know, express and implied are two simple, easy words. If I express disagreement with you, like you could say, I am not happy with the situation. Okay, you just said it out loud. I have no problem. But if you're my old lady and you stomp around the damn house and not say a word for 2 days, I know you're upset, not by your express words, but by your actions. You implied you're upset about something, and it's my damn job to find out. Y'all, I really do get stuff off my chest. Bottom of page 141. You highlighted the source of compensation does not determine agency. The point of that simple statement means who I have a contract with determines where my fiduciary obligations lie, okay? Not where the money's coming from, because the money's coming from the seller. But if I'm a buyer's agent, my loyalty is not to the seller because that's where the money's coming from. It's to the buyer because that's who signed the contract. That's what the meaning of that simple statement is. And if you can recall, I told you, when you get bogged down in a scenario and you can't remember that cold AC, if you'll just substitute the word loyalty for agency, then you'll remember. Because pretty much cold AC, everything within that acronym is a part of being loyal to somebody. So I'm just saying, in a pinch, if you can't remember the intellectual nerd stuff, just hang your hat on loyalty. So, you know, page 142, the fiduciary responsibilities. Guys, because of the fact that we are fiduciaries, from a legal standpoint, we are lumped into an esteemed group of professionals. You know, fiduciaries are CPAs, attorneys, doctors, and us. Are we as sophisticated as those other people? No. But we certainly work in an area that consumers are very naive about. Therefore, they are susceptible to us telling them wrong information because we're incompetent, or wrong information because we're corrupt and trying to get the best of you in a certain deal. So, cold AC, you know, you'll probably have 3 agency scenarios, long questions, you know, where there's people in a property and blah, blah, blah is going on. And then at the bottom of the scenario, they'll say, which of the fiduciary obligations is applicable to this scenario? And you may say, well, that's obedience. Seller told him to hold an open house and he didn't. He went to the park with his family. That's a direct example of failure to obey. You know, so this will be where you need to know that cold AC. Let's turn to page 144. The 3 types of agency, you know, we had this conversation. The real estate industry does not own the word agency. There are 3 general agency relationships that apply to all agency relationships, not any particular industries. So a universal agent, if you can recall, I used Michael Jordan as my example, but what I'm talking about is people who are important and they're not home often. They got things that need to be taken care of at home in their absence. Not only business things, but personal things. And in that instance, I would hire someone, empower them, meaning power of attorney, and they can do anything that I can do. They are me according to the law. Universal, meaning expansive. They can do personal and anything I can do. Top of page 145 is a general agent, and it's exactly like a universal agent, but I'm not empowering you over my whole life, like the word universal would suggest, but just one general area of my life. And a property manager is probably what you have written in the notes. Because think about it, if I have that 100-unit apartment complex and I hire a company to manage it, I have given them some authority. They've got a checkbook with my money, and I've given them permission to spend my money to manage my apartment complex. That's some authority, by gosh. So just one general area of my life, they'll have a question that says, in real estate, who might be thought of to be a property manager? And then a special agent is where you hire an agent for a special task. And when the task is completed, the relationship is over. And in fact, during that relationship, they were not empowered to make any decisions on my behalf. Like when I take a listing, I present the seller offers for them to consider. I will call them on a Tuesday afternoon and say, can you get your family out and y'all go to a restaurant tonight? Because I got a showing. Can I show your property tonight? I ask them if I can do things. So they'll say, who's a special agent in real estate? A listing agent or a buyer's agent? So, over here on page 147, we see the dual agency in the middle of the page. Now, I told you when we talked about this, that like driving laws, 99% of real estate agency laws are the same from state to state to state to state to state. Where states tend to be different is how they choose to handle the conflict of interest. I might close the window. I sound like wind chimes. It's a joke. Alabama, so we could say there's a Coca-Cola and a Pepsi. Coca-Cola and a Sprite. Alabama does Coca-Cola, limited consensual dual agency. Georgia does Sprite, designated agency. Notice I didn't do Coca-Cola and Pepsi because they are very different. Limited consensual and designated agency. See, when the conflict happens in Alabama, we become neutral. We can no longer give either advice that would be harmful to the other. Okay. But in Georgia, if I have a conflict, the broker of the Georgia office will say, Tim, I want you to represent the buyer. Sissy, I want you to represent the seller. And they're going to fight against each other as though they work for competing companies. So while there's two different ways to handle the conflict of interest, they are very different. They really are very different. That's why I said Pepsi Sprite instead of Pepsi. But dual agency, disclosed dual agency would be legit. You see that at the bottom of the page. Undisclosed dual agency would be a result more likely of implied agency, where you did something you weren't supposed to, and the court said you gave the other person the right to think you were their agent. And I even asked you to highlight a sentence that kind of validates that. So you see a non-agency revisited on page 149. You see transaction broker bolded. That happens to be what we call it in Alabama. But now you see the 7 bullets for the termination of agency. You need to have these memorized because you're going to have 2 or 3 questions challenging your knowledge of these bullets. You'll see this in a minute when I go over some questions in the quiz. On page 150, opinion versus fact, puffing. Guys, puffing is an acceptable form of exaggeration. It's throughout the business world, not just real estate. I may be a stockbroker and I may be generally exaggerating about a stock. Oh, the stock is fantastic. I'm not quoting any specific numbers. I'm not promising any returns, but I say, oh, it's fantastic. And then you buy it, lose money, and sue me for saying it's fantastic. the courts are gonna say, Mark had the right to brag on it. He didn't give you any specificities. So puffing, is an acceptable form of exaggeration, where fraud is the worst lie. Just like in real life, there's some lies that feel like a glass of cold water thrown in your face. Fraud is the worst lie in business. You're doing it intentionally for some reason, profit, avoid being in trouble, etc. But then we got negligent misrepresentation, because at some point in time, y'all, the courts used to hold the real estate practitioner liable for passing a lie they didn't know was a lie. Remember the age of the home example? You want to know how old it is? How old is it? They say 8, and I pass on 8, and they move in, find out it's 10. They sue me. I would lose in a court of law. It's called vicarious liability. I don't know if you know what the word vicarious means. But in 1996, they rethought vicarious liability, and they said the practitioner should not be held liable for a little difference between 8 and 10, like in the example I gave, because they're passing on a lie. So they created negligent misrepresentation and said the only time we're going to hold the practitioner liable for passing on a lie is one that was so damn obvious they should have known. So over here on page 151, property conditions, we talk about a latent defect. It's hidden. That's the main thing you want to know. Latent means hidden. You cannot see it visibly. And when we chatted about this as a class, I told you that it's not our job to discover latent defects. We're knucklehead brokers. We are not home inspectors. We are not appraisers. We are not handyman. Latent means hidden. If you can recall, latent defects, the kind of defects both my ex-wives had. Turn the page. So on page 152, we talk about stigmatized properties. Fortunately, Alabama is a state that does not recognize this very silly law. But you highlighted the first sentence in that second paragraph that tells you that some states do. The two stigmas are the house is notoriously haunted or a death occurred recently. Those are one of the two. And in some states, if that is true, you got to tell a potential purchaser. We don't in Alabama. Megan's Law. The courts have specifically said it is not a real estate practitioner's job to discover and then disclose the presence of sex offenders. It's the buyer's job to discover that on their own. But some states, you highlighted it in that second sentence in the last paragraph on page 152. Some states require that we at least provide the website to the buyer so they know where to go and discover sex offenders. Alabama does it. I told you when we talked about it, there are a few companies in Alabama that do, that I know about specifically. And then we're on the key point review. So let's dive into the quiz and talk about a couple of questions. There'll be a lot of questions like number 4. Just based on what was said and what was done, you've got to ascertain the relationship. The answer there to that question is B. Seller's a client, buyer's a customer. Guys, you'll probably have 4 questions with a scenario like that, and you're to take the words in the question and make the determination of who's client, who's customer. And we talked about that. The words with and for. I don't know if you remember that. You work with a customer, you work for a client. Assist versus advise. You advise, you assist customers, you advise clients. But look at page 6. Remember, I told you the 7 bullets for why an agency relationship could be terminated. And I told you you're probably going to have 3 questions on that. Look at number 6. Which event will terminate an agency? It should say relationship. An agency relationship and a broker-seller relationship. Oh, that would have been redundant. The answer is B. If you want to write page 149 somewhere around question 6, because that's where the 7 bullets are. So when you're outside of class, you'll see that. But the owner abandons the property. I mean, a lot of vacant properties have been abandoned and are sold daily. What's another one? The broker appoints other brokers to help sell the property. That's MLS. That has nothing to do with a termination of a relationship. So yeah, B, You know, how are you gonna sell something that now the courts are in control of? Look at it, number 7, designated agency most likely to occur when, and this would be Georgia. The answer is D. Both buyer and seller are represented by the same company. The word represented indicates client relationship. Because think of it, what does an attorney do to us? They screw us, is what they do. Get the bill? Yeah. But they represented us, yeah. So, you know, it may say, XYZ Real Estate is providing agency services to the Hendersons. The Hendersons are clients. When I say agency services, that means we've signed an agreement and we are now your agent. So represented agency services, they're not always going to say they're a client. You've got to take the verbiage. Here's another one, number 9. I told you there's going to be at least 3 questions. Which of the following is not a valid reason to terminate an agency relationship? And the answer is C. Buyer wanted to work with a new agent, but the terms of AC had not yet expired, and the current agent did not agree to terminate. I think if you read the 7, you will understand why A, B, and D. I really don't like C. Because we learned in C that either party unilaterally has the right to back out. Do you remember us talking about that? Now, it doesn't prevent the other party from suing you, but either party has the right to unilaterally back out of an agreement. So I don't like the way that's worded. But with the 4 choices, that would be the closest to being the right answer. And that's going to be the basis for you arriving at some of your answers. Moving on, number 10. With the top of page 156, question number 10. A seller tells his agent the 2 words. There's always a word or 2 that are the key words that dictate the answer. In confidence, those are the 2 key words. That he must sell fast and may accept less than the list price. Guys, let me tell you something. I see it all the time. Motivated seller. What kind of offers do you think that wording is going to attract? Lowball offers. Now, if your seller is motivated and they need to get out dire financial reasons, and they tell you, let the whole damn world know, then put motivated seller. But if I tell you in confidence and then you use that word, you might have violated confidentiality. So you don't want to casually use motivated seller unless they're begging you, get this damn house sold. If we can get 50% of what it's worth, we're okay. We got to get out of here. But the answer is C. Disclosure was improper and possibly illegal because it was told in confidence. But I always, if a seller said, Mark, help me get rid of this property, I would say, are you okay with me using words that are going to attract lowball offers? I have said that 1,000 times. Look at question 12. Guys, at one time tonight, we just, during this course, we discussed something. And most of you knew it. But there's 2 kinds of law, criminal law and case law. And sometimes case law is called common law. Up until 1996, if a buyer wanted to sue a real estate company or a real estate company wanted to sue another real estate company, they did so in civil court because it was common law at that point. But then in the mid-90s, states began to make this common law actual statutes. So now if you violate some of these things, you're breaking the damn criminal law. Okay, so that's what they're talking about. What does the phrase the law of agency as a common law doctrine mean? The answer is C. It's a part of body of law established by tradition and court decisions. If you've ever heard of legal precedents, that means previous court decisions. Again, there's page 14, number 14 rather. This is where you would need to know cold AC. Real estate sales associate represents a buyer. At their first meeting, the buyer reveals plans to operate a dog grooming business out of the purchased house. The sales associate looked at a bunch of properties, but failed to look up the zoning ordinances. This is an example of care. It's not obedience. The buyer didn't tell him to do something. He refused to do it. It's not a matter of being disloyal. So as a test taker, I would have been between A and D. And there's really no failure to disclose. It was just a failure to look something up. And if you look up the definition of care, it just says that a real estate agent is expected to at least be a little bit smarter than a consumer. So that means you're going to check on things that I wouldn't know to check on. Again, another one right there on number 16. A real estate broker's responsibility to keep the principal informed of all facts that might affect the transaction is disclosure. Okay. So I think we've already had a bunch of questions having to do with page 142 and the 7 bullets on how an agency relationship can be terminated. All right, look at 17. Which of the following is considered dual agency? And guys, purposely, and the exam people tell us to tell you this. On every exam question, there are 2 answer choices that are ridiculously far from being the right answer. But on purpose, there are always 2 answer choices that you got to, you know, both of them close. And this is one of them, number 17. What is considered dual agency? A broker acting for both parties in the same transaction, or C, a broker representing more than one principal. Do you see how similar those sound? Yeah. But what they're saying is, I may own Mark Yarborough Real Estate and I may have 85 listings today. That means I have 85 principals. None of them are negotiating with each other. So dual agency is when they come together in the same transaction. Let's flip on now to unit 10. And guys, what we're going to do is take our only break. So we're going to take our break right now till 7, and then we're going to come back and we're going to wrap this evening up, hopefully get out around 8:15. Okay. So let's take our last break tonight. See y'all back here in a minute.
I didn't know this about it, like. Exam or no?
Make that arrangement with the office, with the girls. I think so. Yeah. I think you could come in the morning if you wanted to. Okay. Just make that arrangement with them. Yeah. Here we go, gang. We're back from break. We're on page 160. Okay. To my students, we're back from break and we're on page 160. It's difficult to pass this exam just by memorizing definitions. That's why I labor selling concept. I teach you the concept. That's why I use the examples. Because if you don't understand the concept, it's just difficult to get questions right by memorizing definitions. So, we talked about this. Prior to the 90s, we did not have exclusive arrangements with people. Well, we did with sellers. We didn't with buyers. If you can recall, I said, you could spend 2 weeks showing a buyer property. And then call them up one night and say, hey, you want to go again tonight? Look at some more. And they said, well, we bought one yesterday, Mark, from another agent. I didn't get paid. I had no exclusive agreement. They didn't exist at that time. So again, it was in the mid-90s when nationwide companies, the industry began changing. And one of the changes was we felt the need to have exclusive arrangements. We wanted to have some assurance that we would get paid from extending energy and effort. So there are 4 types of listings. We taught it with a totem pole in class. At the top of the totem pole, the exclusive right to sell. That's the best one. It's the best one you can get in the biz. And frankly, even though they got 2 paragraphs, it's real simple. Beginning and ending date. Beginning and ending date, and can't have automatic extension clauses. We understand that. Okay. Beginning and ending date, no automatic extension clauses. And if the property sells between the beginning and ending date, the listing company gets a commission, no questions asked. Now, we talked about having to sue for a commission if they refuse to pay. But regardless of who sells the property, listed companies getting a commission. Number 2, moving down the list, the exclusive agency, it is identical to the one above it, with the exception of, and you highlighted it, the italicized sentence, the seller retains the right to sell the property without having to pay the broker. I gave you an example of me taking a listing, an exclusive agency listing, and my seller calling me up one night and saying, Mark, I got to talking to my son, and he's going to buy my property. He's going to take it off my hands. That way it's still in the family. But thanks for all that you did. I'll holler at you down the road if I need you again. That would be an exclusive agency. But you can also maybe recall that I told you the practical reason that the industry came up with the exclusive agency listing was if I'm calling on a for sale by owner. And that for sale by owner says, Mark, timing's everything. And you're right. I'm ready to give up trying to do this on my own. So I am ready to list with someone like you. But dang, Mr. Yarbrough, I've shown this to 5 families. If you put a sign up my yard and then one of them 5 families comes back and wants to make an offer, I'm going to feel like I don't owe you a commission on that one. I say, I completely understand your logic. Do you have the names of those 5 families? And I would make them a part of the listing agreement. Those would be the exclusions. That would be a practical way to take advantage of an exclusive agency listing. That way, if one of those 5 families stepped up and bought the property, the seller would not owe me a commission. And that might have been what I had to have to present to him as an alternative to the one above it to get him to list with me, if that makes sense. An open listing, we said there's no exclusivity. I could literally have 32 real estate companies and all 32 of them have a sign in my yard. But the only one I'm going to pay is the one that physically brings me an offer that I accept. Net listing, illegal. And it's where the commission is not defined. It's not quantifiable. It's not expressed as a percent of something. It's not expressed as a fixed dollar amount. It's expressed as my commission will be everything over and above this price that I sell it for. And that is a huge question mark. So let's go into the top of page 163. Again, for repetition, we want to be reminded that a listing agreement has to have a beginning date and an ending date, no automatic extension clauses. We talked about the broker protection clause. This is a period of time that piggybacks the listing period. And this is a clause that literally protects the broker from getting cut out of the deal. You know, the seller telling the wannabe buyer, hey, wait 2 more days, let my listing expire, and then I'll have some wiggle room and we can negotiate. That's somebody trying to cut me out of the deal. And that's what the broker protection clause is for. The CMA, middle of the page, we have highlighted. This is a fancy nerd name for the formula that we use. I say formula, it's not a formula, but it's an analysis that we use to come up with a asking price on a new listing. It's a very watered down version of what appraisers do. But guys, we have access to MLS. We have access to comps, that have sold. And there are programs, once you get in the business, that will specifically help you do some CMA. Turning the page. Not a lot over the next few pages. But on page 172, the second half of the page is a variety of ways that they could ask you a commission question. Some commission questions, you got to come through the front door to solve it. Some you got to come in through the back door to solve it. Some you got to come in through the side of the house through the screen door. But, some of them, they say, what was Mark's rate of return? Well, I don't know if it's in this one, but nevertheless, they got all the ways you can need to arrive at the commission.
You said all the math questions, us to know the formula, correct?
Yeah, all the math questions, listen, right in here. Real estate calculations. There'll be from property area calculations. There are 2 subjects, square footage or acreage total. There'll be 1 question from either of those 2. If you remember square footage, length times width equals area. And the acreage, 43,560, all that. And then B, under real estate calculations, there's 6 items, only 1 question. One of them is a CMA. One of them is net operating income, capitalization rate, equity in the property, establishing a listing price, assessed value. Out of those 6, 1 math question will come. But you have this, so you can look at it. What I'd like for us to do is move into page 184. We're going to go over some questions in the Unit 10 quiz. I'm talking about the state exam, Christy. I say that, we pull resources from the publisher. The midterm you took was from the publisher of this book. They provide schools that use their book wonderful resources. The final exam that I'm going to give you is from the publisher of the book. The final exam that you're going to take is the final exam that 80% of the people in the country are taking. So I don't know if they compose their final exam to Pearson VUE. I wouldn't think they would, because this book is sold to schools throughout the country and not every state uses Pearson VUE. So I doubt they set up the final exam exactly like this outline, but it's the same material, just a different allocation of questions from certain subject matter area. So look at question number 3. We're on page 184. You're welcome. I had to see what the message was. All right. Look down here at question number 5. I'm going to pull up the whiteboard. Dooby-doo, dooby-doo-doo. Doo-doo. Oh, wait. First of all, I just realized I casually forgot to discuss question 3. I sat there and mentioned it and I got sidetracked. Let's look at 3. The listing agreement on a residential property states that it will expire May 2nd. Which event would terminate the listing before that date? So this is where the 7 reasons for the terminate, we're seeing this in yet another subject area. The answer is C. Now, a lot of them, they kind of want you to think B. Now, if either party in a listing dies or becomes significantly disabled, that will cause a listing to go away. But being merely ill is not significantly disabled. Okay, so that's why you would choose C and not B. But look at question 5. This is where I'm going to pull the whiteboard up. You may can recall, let me close this out because I got to do something that I forgot to do. Whiteboard. Yeah. Okay. Do you recall me telling you that a formula you'll be able to rely on is a small over percent time big? That this is real similar to the I over R time V. But right now I want to focus on this. Look here at question number 5. You see 2 numbers in there. And one smaller than the other. And they're asking for a percent. So if I do the small over percent time big, I got 26,675 on top. And then I put the big number down there, 485. And I think y'all know what to do when you got 2 numbers with a line between them. I would divide 485,000 by 26,675, and I would get the answer of B. Okay, so this is a great small over percent times big. Let's look real quick at question number 10. Gotta close this and do a new whiteboard. So all right, now watch this. The answer to number 10, we're on page 185, is 183. I'm just going to go ahead and skip to the answer so I can begin showing you. Now, if the question was worded this way, and they said, if the commission was 6.5%, and the sales associate got 30% of that, what the sales associate make? Well, you would say this times 6.5, okay, percent. What is it? Does anybody know? It's 11,000 and something. 1,183,333
17.
and some change.
Yeah, but like it's 16.6.
I got you. So then I would do this times 30%. Thank you, Tanya. Times 30%. 575. So, you know, we started with a big number, and to get to the smallest number, we multiplied going downhill, right here and right here. So let's reverse it. If it said, you know, the agent made 35.75, which is 30% of the company's 6.5%. We divide going from small to big. So I would say, what is 35.75 30% of? Well, the answer is 11,917. And what is 11,917 6.5% of? The answer is 183. So when you start small and you're trying to arrive at a big number, you divide going downhill. When you start big and you're trying to arrive at a small number, you multiply going downhill. Some of y'all, again, are laughing at me. You've known that kind of math your whole life. I just figured that out a few years ago. And I've been excited ever since. I like to brag in class that I know how to do stuff like this. But that's question number 10. Look here at question number 13. You know, we went over the 4 listings. they're gonna have a buyer agency version of those 4 types of listings. So a buyer signed an agreement with a broker to compensate the broker, even if the broker purchases the property from a relative. This would be the equivalent to an exclusive listing. So the answer would be C. I don't like that question. Compensate the broker, even if the buyer purchased the property from a relative. So that means I get paid. So C is the equivalent to an exclusive right to sell, is what they're saying. But over 15, you had to understand the concept of a broker protection period. Seller sold property to a neighbor without the services of a real estate broker. However, the seller still owes broker a commission because the seller signed C. But how? Because it says without the services of a real estate broker, the broker protection period would be involved. They don't mention it anywhere, but that's how. The listing expired, yet they still owed a commission. That would have to be because of a broker protection period. I'm assuming I'm reading that into it. Question number 20 on the next page. Anticipate this question where they're trying to fool you. All the following are valid reasons for terminating a buyer representation agreement except the answer is B, because it's not the death of the sales associate, it's the death of the broker. And they're going to try to fool you on one of those. The broker's got to, the sales associate's invisible, kind of, sort of, remember? But anticipate them trying to fool you on such a question. So we just covered chapters 8, 9, and 10, which was agency. We hit the surface. So now on page 187, we're going to wrap tonight up by covering real estate contracts. Now, here we go. We check out a couple of the chats. My admin is on vacation. All right, here we go. We can go ahead and turn the page. We're not teaching this like we did normally. So on page 189. Page 189. Hey.
13, number 20, or did you say 15?
I did reference 15. Yeah, that's all right. So over here on page 189, we talked about the fact that the law calls a contract that both parties fulfilled their obligations an executed contract. And we talked about the fact that when you have offer and acceptance and the delivery of the accepted offer to the person that made the offer, that is the official creation of a contract. And then we usually set a 30-day period before we close. Me and you, we regular people, we use regular words. We're going to call it pending. Nerds are going to call it executory. This is the present tense of the word execute. It's in the process of being executed, which is executory. So pending, executory. Now you got at the bottom of the page, offered acceptance. Really, the formal, that's slang. The formal is mutual assent. But then I told you I'm getting feedback from students that there's a question that says, what's another way to say mutual assent? The answer is meeting of the minds. Hopefully you highlighted that out to the right. Two minds come together, they meet. Hey, how you doing? Page 190. Bottom of the page, consideration. There's two kinds, valuable. That's the most common. More often than not, we're talking about money. But it can be whatever both parties agree to as having a certain value. One of my students has a question. Yes, dear? Then I have some students tell me that there's a question on the exam that says, what's another way to say mutual assent? And the answer would be meeting of the minds. Now, valuable consideration. But good consideration is love and affection only suffices with immediate family. Top of page 191. They should have added the word genuine. I think that was an accidental omission. Genuine consent means free from duress. We gave you an example of duress. It's an ugly situation where someone's kind of trying to use their leverage or extort you or make you do something you really don't want to. Where it says legally competent parties, we know that that means legal capacity, and legal capacity means two things: contractual age, sound mind. Second half of the page, validity of a contract. And the context of this is its enforceability, because we've talked about the fact that there's criminal law and there's civil law, but you can't take any knucklehead dispute that you've got to civil court, because we said if you could, it'd be Jerry Springer every single day. And the courts need to be reserved for serious matters. I don't need flim-flam matters like they got on the TV. So in the context of enforceability, we learned that a contract has to have a certain number of ingredients for it to be a valid contract. So valid and void just means, is the recipe complete? And you got to know the recipe. Avoidable contract, there's 5 instances where a contract could be determined to be voidable. A minor's involved, misrepresentation, alcohol, duress, or a temporarily not of sound mind situation. According to my students and feedback I get, there'll be an alcohol version of that question. Somebody was inebriated, and maybe that's why the agreement's not enforceable. And according to feedback from students, there is a temporarily not of sound mind situation. And frankly, all 5 of the reasons it could be voidable are in that bottom paragraph at the bottom of page 191. So on page 192, an unenforceable contract, meaning a contract could be unenforceable for 2 different reasons: statute of fraud or the statute of limitation. And if you can remember, the statute of fraud is a particular rule that the courts rely on when there's an enforceability question. But in the context of real estate contracts, all I want you to know, all we need to know, is that statute of frauds means if it ain't in writing, it ain't enforceable. And again, that rule only applies to real estate contracts, not other ones. Like a personal property, I'm buying a car from you, that can be verbal and be enforceable. But real estate contracts, again, real estate's very serious, much more serious to the courts and the law than a car. Performance of a contract. In the middle of the contract, we talked about the fact that the person making the offer, there's a particular clause that says purchaser intends on closing blank. So I might, if I'm the one writing the offer, I might purchaser intends on closing May 29, 2023. Does the deal have to close on May 29? No. As long as both parties are diligently doing what is required of them, then the contract can continue to be delayed. Okay. But sometimes, by gosh, one of the parties wants to hold the other party's feet to the fire. Maybe the circumstances in my life are saying that I cannot go beyond this day that I want to close. I have to close. So I would put purchaser intends on closing, and then I would write by May 29, 2023, with time being of the essence. If I add those additional 5 words, and you're the reason that this deal don't close by midnight of that day, then I can sue you for breach of contract. It's a way to actually force someone, by gosh, to do what they got to do by midnight of a certain day. The bottom of the page, we talked about assignment. Hey, it happens. I got to get out of an agreement. It's my life and its circumstances. So, okay, it's common. So, yeah, assignment refers to a transfer of rights or duties under a contract. If there is transfer, no term in the agreement changes, just the parties. But the agreement stays the same. and I wanted you to highlight the booger of an assignment, is that the original party can be held liable down the road if the one that the obligations were transferred to drops the ball, so to speak. So that is a distinction between assignment and novation that I think they're going to want you to know in the exam. Novation is a first cousin of assignment. There doesn't have to be a substitution of parties. I'm coming back to you, but there could be. But if there's a change of terms, according to the law, if you change any term in an ongoing arrangement, you tore the original agreement up and are substituting a new one in its place. Hence the term nova, which is Latin for new, like a new star is a nova. Yes, sir?
So, assignment, how that different from assumption?
An assumption is an assignment. I love the fact that you asked that question. He said, Mark, how is an assignment different than an assumption, like on a mortgage?
I assume you're right.
Yeah, no, I love that question. If I'm picking the ball up on, they used to put ads in the paper, pick up my car payments, assume the note on my car. That is an assignment technically. Yeah, the parties are substituted, no term, and the original mortgage will change. I love the fact he asked that question. I've never even had that asked. I love that. An assignment effectively is a loan assumption. But if one term changes, by gosh, it's novation. And the cool thing on novation, if there is a substitution of parties, the original party has no future liability. Whereas the original party in assignment could have some future liability. And from what I understand, as far as feedback from students, that is a distinction between the two that they're going to test you on. So breach of contract is self-explanatory. Each party has a set of responsibilities. One party fails to meet their end of the bargain. They failed to do what they said they was going to do. Therefore, the other person is said to now be legally injured. They have suffered from your non-performance, or, attorneys will say your default. If you don't do what you're supposed to do, you default. So we discussed the fact that the legally injured party could sue you for damages. That is a legal remedy for that legal injury that the courts provide. But again, we emphasize more than once that the courts take real estate much more seriously than they do other things. So if you're legally injured in a real estate contract, you have an additional remedy, and that is you could sue them for specific performance. You can make them follow through and do what the hell they said they were going to do in the agreement. I don't want no money. I want the property. But we also, while we were talking about that, we discussed the fact that in residential real estate, suing is not practical. Commercial real estate, everybody got a suit and town. They got briefcases. They got attorneys on retainer. They're uptight business people. They sue. But in residential real estate, we're mamas and daddies with youngins. We're trying to live life. And suing somebody is just not a practical solution. So that's why we invented earnest money, to give the seller an alternative to suing, a deposit, if you will. So look at that fourth paragraph under breach of contract. You probably highlighted that first sentence or first two sentences. If you see anything having to do on the exam with liquidated damages, they're talking about earnest money, because it's where, and there's a clause that mentions the earnest money, and it basically says if buyer defaults, seller chooses to accept earnest money, deeming them to be liquidating damages. Meaning it's just saying the seller is choosing the earnest money versus suing you. So a liquidated damage clause is just talking about the earnest money. Now on page 196, guys, when I'm a seller, I have a sign in my front yard trying to sell my property. I get an offer. Maybe I'm trying to sell it for 200. We get an offer for 195. Now, if my listing is brand new and I've got a nice home, It's marketable. It's in good shape. And it's in a nice neighborhood where properties move fairly easily. And the economy is great, meaning every box is checked. Even though it's a risk to sit on a legitimate offer, there would be a legitimate reason to sit on that offer, right? The situation says, sit on it a couple of days. But we must understand that you're taking a risk. The old bird in hand is better than two in the bush is where that comes into play. If I sit on this offer, waiting on something better to come along, I may get a text going, Mr. Yarbrough, we have rescinded our offer. And I'll be like, I'll be damned. I was sitting there holding that bird and I let it fly off, waiting on something else. So yeah, a seller is taking a risk when they are sitting on an offer because the buyer can rescind. It says right there, second paragraph under counteroffer says an offer or counteroffer may be withdrawn at any time before it's been accepted. Now over here on page 197, I think you can recall me telling you that in most states, the seller is responsible for the property all the way to closing. So if during the executory time, the property is damaged, hail, storm, hurricane, tornado, fire, seller's responsible for it. That shouldn't even have to be something taught in a damn class. Any reasonable person would go, I get that. But I'll be damned, if when I started to teach and started teaching national real estate, I discovered the fact that there are some weird states that expect a buyer to insure the property from accepted offer all the way to closing, as weird as that sounds. So this is what we were talking about that. You highlighted the sentence that says equitable title may give the buyer an insurable interest in the property. What they're saying is that when you have accepted offer and you have a pending contract, in those states, the courts have said that the buyer has equitable title. It's some concocted BS. But apparently, when you have equitable title, you can now insure the property. I'm waiting one day to talk to a practitioner from one of these states. I want to know how that works, but I've yet to meet one.
Do you know what it's saying?
I don't. Yeah, I don't. I may write myself a note. Let me do that.
Well, how would that look on a test?
I don't know. You know how many times I've been to the exam site? Twice. When I passed the salesman and when I took and passed the brokers. They have not let me in the exam site since. They give me, some things to, to hip you on, and I get feedback from students, but I wish I could be more. Huh?
Can you make that a question? Or explain it again, because I'm kind of.
In most states, the seller is expected to insure the property to closing. But weirdly enough, apparently, in some states, the buyer is responsible for the property while it is pending. Yeah. In other words, if the property burns down, the buyer is responsible. It makes no sense. Makes no sense. It's kind of like in the 1 hour that I'm haggling over a car on a car lot, if that car catches on fire while I'm haggling, I'm liable for that car. That don't make no sense at all, does it? But apparently it's true in real estate. So in those states, they have invented this equitable title crap. That supposedly a buyer has equitable title during the pending period, which gives them the ability to insure it. I don't know how to explain it any better than that because I'm kind of naive about the concept, honestly. I only know what I just told you. It's very strange. Over here on page 199, we talk about contingencies. And guys, you want to be able, as a buyer or seller, on occasion during negotiations, to be able to build a back door on this deal in case things ain't working out like I thought. I want to be able to turn around and leave. there are common contingencies. If you're unsure about your ability to get financing, because maybe, about a year and a half ago, I got in a pinch and I was late on a couple of credit card bills. So I haven't gone to see if I can get financing. So I'm going to make this offer contingent upon my ability to get approved for financing. So that way, if I go to the lender and they say, you're right, Mr. Yarborough, them 3 lates from a year and a half ago are going to prevent us from approving you. I thank God I built a back door on this offer. Now I can skedaddle.
So, okay, so going back to find a ready, willing, and able,
Mm-hmm.
okay?
Mm-hmm.
So I got credit problem.
Okay.
I didn't go and check it out.
Okay.
I didn't build any contingency,
Okay.
and so I can't get financing.
Okay.
I don't have cash. So am I truly a ready, willing, and able person?
No, you're not. All right. First of all, and I see you bringing these two together. I think he was close enough to where I bet you guys heard him, but he went back into the past, this evening's past, and referenced, okay, ready, willing, and able buyer. Mark, if I can't get finance, here's the context of where we're at. Let's say I do make an offer, but I don't build this offer is contingent upon my ability to get financing. I go to a mortgage lender and they say, Mr. Yarborough, we can't give you financing. I go to multiple lenders. None of them will give me financing. And I go to I tell the listing agent, I tried to get financing. 7 different mortgage companies told me they ain't going to give me financing, so I can't get financing. Don't you remember? The seller can sue you for damages or specific performance. They're not going to be able to successfully force you to buy the home. You can't get financing, but they can get a judgment against you, which will affect you for the rest of your life. Remember, if I get a judgment against you, I can file a writ of execution, which compels the courts to discover if you own anything and then force the sale of it. So that's kind of that's why I would want to put a contingency. We talked about the property sale contingency, the booger of all contingency. This offer is contingent upon my ability to sell my home. So if I can't sell my home, that can prevent them from suing me and forcing me to buy their home. So again, the need to sometimes, like a home inspection, I make an offer on a property, I don't put a home inspection contingency. And then we close, I buy the property and I find out I bought a lemon. Heating and air don't work, roofing's caving in. So now I just put myself in a very terrible situation. So I could say this offer is contingent upon me being satisfied with a home inspection that will be performed within 72 hours from the seller accepting this offer.
The real estate agent have to know beforehand, before there's even like a contract or contingency, if their financing wasn't going to be available for them.
Yeah, and we're starting to conflate multiple things in these scenarios. I appreciate you thinking. But
In reality.
what it is in real life, when I take on a buyer client, if I'm a prudent agent, I'm going to make sure they get pre-approved before I go show them properties. If you don't, then you're susceptible to wasting your time, But yeah, as a buyer's agent, I'm going to make sure my buyer's pre-approved before we get out in the streets and get out. At the bottom of page 199, amendments and addendums. Now, gang, the words look similar. They sound similar. So on any question, well, one of them's the right answer. They're both going to be offered as answer choices. An amendment is a change, like a constitutional amendment. I gave you an example. I was buying my mama a condo and she saw an armoire in the bedroom, took a breath. She was like, I can't imagine owning such a piece. I said, you want it? She said, yeah. So I put this offer is contingent upon, I didn't say contingent, but I said seller to leave armoire in bedroom. They signed it, accepted it. Then I told you 2 weeks later, the man called me, he said, Mr. Yarborough, the only reason that's been in my wife's family for 50 years. The only reason she agreed to give it up is because I'm going to lose my job if I'm not in Nashville in 3 weeks because I got transferred. And I've been holding them up because ain't been able to sell my condo. They finally putting some heat on me. So my wife begrudgingly accepted that offer, me and her. And she ain't stopped crying since. And I'm calling you to see if we can get it back. I said, yeah, you can have it back. So I had to amend the contract. Seller will no longer leave Armoire. Buyer and seller change their mind. Seller will keep Armoire, and I got seller to sign, buyer to sign. I didn't go into the original contract and start Xing some crap out and writing some new stuff. That ain't the way you change a contract. Like, if you remember, when you got a contract, you might as well take a picture of every page, because you're not going to put pen to paper, never again. If you make a change, you do it on a clean piece of paper and make it a part of the purchase agreement. An amendment. An addendum, we turn the page, I want you to associate with negotiations. I told you. This last summer was unique in the history of real estate in the United States. Properties were selling in 24 hours. So the seller never had a chance to A, go shop for a few weeks, B, make an offer, and then have 30 days. So a lot of sellers were forced to rent their own damn house that they just sold a buyer for a period of time after the closing. So you would have to have a rental agreement that's a part of the primary agreement. Again, I made a little joke. You know, it's a tiny agreement contract in and of itself that's associated with a bigger contract. Like I told y'all, a girl may ask me out. I say, I'll go out with you. That's a contract right there. Will you go out with me? I'll go out with you. That's an expressed agreement. But then I say, only if you take a shower. So that's a separate agreement that must be met for this first agreement to be met, right? But they're both associated with each other. It's like the rental agreement is the cowboy riding the horse. The horse is the purchase agreement. But the cowboy is a little agreement that goes with the big agreement. So addendum, you know, you see right there, may change or be in addition to the content of the original. Like, again, here's the thing. Every company has a standard contract. You'll hear, if you've never heard it, you'll hear a standard called boilerplate. Everybody's got a standard contract. So it's very usual that the buyer and seller want to negotiate on something that is not addressed in a boilerplate contract. So what do? That's when you go get the clean piece of paper from the copy machine, address it on that, and then make it a part of the purchase agreement. So they're both amendment or addendum made a part of the purchase agreement, but the addendum is part of the negotiations. There's something that the buyer and seller want to negotiate that is not addressed in the standard agreement. With the amendment, we had a contract, now we're after the fact wanting to change it. Options. Hopefully y'all highlighted that third sentence, because I'm getting feedback that that's a question on the exam. So let's say I meet with a man, you know, and I say, Sam, I want to buy you 60 acres, but I'm not sure I can get the finance, and it might take me a week to find out. Will you hold it off the market for me for a week? I sure would appreciate it. So I'll go spend 3 days with the lender. And after crunching numbers, the lender goes, Mr. Yob, we can give you financing. So I'll go back to Sam. Is that what I was calling him? I go back to Sam and I say, Sam, you know, I got the thumbs up from the lender, man. So let's get the paperwork out. Let's do some more. Mark, hell, I got to talking to my boys last night at the dinner table. They come over to visit me and the mother. And they want to get it from me. They want to develop it. They want to put something on it. They don't want me to sell it to nobody. And I say, the hell, Sam, me and you got an agreement. We shook hands. And he says, I'm sorry, Mark. I try to sue Sam. And the judge is going to say, Mark, I know you're upset, but y'all didn't exchange valuable consideration. You just had a handshake and a witness. I can't enforce this agreement. Okay, Sam got the right to do with his boys what he wants to do with it. That the optionee pays a fee as valuable consideration for the option right. I just added the word valuable. But I'm having feedback that there's a question on there that an option is not enforceable in a court of law if valuable consideration was not paid for. And if I do buy an option on a piece of property, we determine the terms of the purchase at the moment that the option is bought. Does that make sense? Because what if I made a man hold a piece of property off the market for 60 days, and then I went to him and said, I want to make an offer of $100. He'd be like, that's ridiculous, Mark. I've had 5 buyers come to me in the last 90 days, and I turned them away for you. Now you trying to buy it for $100? What is this, a joke? So for that reason, the terms of the purchase are arrived at when the option is bought. Now, at the bottom of page 200, owner finance. So if you come to ask me, Mr. Yob, we want to buy your house, but you know, me and the wife had some slow credit a couple of years ago. We're not sure about financing. So would you tote the note? Would you agree to owner finance? I say, yeah. I've got two choices. I could do a purchase money mortgage, or I could do land contract, contract for deed, installment sale, or bond for title. Again, regional, interchangeable, synonymous terms. The two things I wanted you to know about each is in a purchase money mortgage, purchaser has legal title throughout the loan. And if the purchaser defaults on the terms, the seller would have to foreclose. Easy enough. Those are the two things. You foreclose if the buyer defaults, and the purchaser has legal title. Whereas on a land contract, contract for deed, installment sale, bond for title, the seller retains legal title. And if the buyer defaults, you don't foreclose, you evict. Now, guys, it doesn't matter which the seller chose. The buyer has the same rights, obligations, and privileges under both. It's an ownership. In other words, does the buyer got to pay property taxes? Yes and yes, regardless of which type of financing the seller chose. So the buyer's rights are not reduced because they did a land contract. No, they get the same rights under both. So we're done, gang. You know, an early night, time to go, you know, maybe tonight you get home and you can read a book for the kids. You know, y'all reading books for your damn kids? You need to be.
Want to go over the questions?
My mom and dad didn't read no books to me. Look how damn broke I am. I need fixed. So go home, have dinner, hug your kids, and be careful going home. I'll see y'all tomorrow evening at 6 o'clock, and bring your law material, probably like you did tonight. Y'all be careful going home. I'll see y'all tomorrow night at 6 p.m. If you've got any questions, hit us up on My Real Estate School's Facebook page or email Ashley. We'll see y'all tomorrow night. 1 second. Very good.